let me state it again. It was a long question, Judge. The question that was posed to the Bar Association and to the First Circuit is a question whether, this is how it's phrased, typically,
the summer.
Typically the court slows down in the summer, and what y'all do about it.
Well, right now I think we have 24 cases that are multiple, either special cases requiring special panels other than the normal configuration of our panels, or they're cases that have gone to a 5-judge panel. And we are going to set those in June. I don't recall the exact dates. I want to say around the middle of June. But we will probably hear those cases with a Zoom process like we're doing now. And so as far as the summer goes, we're not really, you're right. Normally we do have a time there where we kind of catch up on our regular dockets from the rest of the year. But this summer we will be catching up on the dockets that we didn't get to because of the situation we're in. And those 24 cases at last count, with multiple different panels, different configurations of panels, will be heard probably in about the middle of June. And then the rest of the cases that are our normal docket cases will be assigned and heard shortly after that. So we may look similar to what we have in the past in the summer, other than that June docket, but that's because we're working from home.
And let me add the dates we're talking about in terms of it's going to be the week of June 15th. And of course, you'll continue to get your 30 days notice in advance. In addition to that, on the 4th of July, we are setting a submission date for non-orally argued cases, which are a part of the next regularly scheduled docket. And then in August, we will have hearings again by way of Zoom on those cases which are on that next regularly scheduled docket that are scheduled for oral argument. So we'll be working throughout the summer, and also we will continue to be having writ conferences during that time. We had 2 writ conferences this week by Zoom. We have another one scheduled next week by Zoom. So the court is continuing to process cases and writs using the technology that's available.
Michael, I think you're up next.
Good morning, judges. And I think this next question kind of touches on what Judge McDonald and Judge Guidry mentioned. It says the Louisiana Supreme Court has recently said previously canceled or delayed oral arguments for June, and they will utilize Zoom. Does the First Circuit anticipate using video conference technology for oral arguments? I think that you all may have touched on that, but if you want to add anything, I think it might be helpful.
Judge Welsh.
Yeah, I think I've got it. Listen, first thing I want to say is our prayers, our thoughts are out with you. I cannot even imagine the challenges all of you are going through as we go through this pandemic and meeting with clients and being worried about family. I can't imagine what all of you are going through. So our prayers are with you, with all of us. As we embark on this new use of technology, I want to say that we're going to have those hearings in June. It'll be this, I think it's the 16th, 18th, and 19th of June. You'll be getting notices shortly about the cases that were previously setting those. Now, many of those will be 5-judge panels, but there will be some special panels and special configurations. Those cases are set to be heard by Zoom. Now, we realize that all of you are not hooked up technologically to get your clients in, to all the protocols that we need to set forth in getting those matters set in June are going to be by Zoom. Now, if you are not able to do that for some reason, make sure that you file a continuance and give us your reasoning, and that you need to continue that, because we're, you know, justice delayed is justice denied. We're trying to get these things out of here for you, but we want to make sure it's done in a fair, even-handed way, so that we can make sure that justice is done. Now, the conferences that are going to be held in August, again, may be by Zoom, may not be. We haven't made that call yet, but definitely the ones for June will be done via the Zoom platform.
And Judge Welsh, as chairman of our technology committee, has already worked with our IT people so that when our clerk sends you the notice that you're going to have a Zoom oral argument, they will give you the protocol to contact our court so that you can test your mic, test your cameras, and you can work through that Zoom process with our court to make sure when the hearings are ready to be held, you will be able to come in smoothly. So we will allow you that opportunity to test your equipment.
Thank you, Judge Guidry. Mary?
Yes, and I think perhaps the next question on our list may have already been covered, but it was, is the court reviewing or deciding cases that were fully briefed and argued before March 2020, or is everything shut down? And I think you've kind of addressed that, but.
Judge Higginbotham, would you like to add anything on that?
Your mic, Judge Higginbotham.
I'm answering. Is anybody hearing me?
Yes.
Yes.
Okay. I think everybody just needs to understand that although our building has been closed officially, all of our staff that can, and most of them can, have been working from home or wherever they happen to be hanging out right now. So all of the cases that have already been argued are in the pipeline. And for instance, I know for my panel particularly, we've exchanged the cases and we plan on signing them. I think it's May the 5th. And so all the panels are doing their own dates instead of having a one date that we had before. But I think all the panels will hand down the cases in the next couple of weeks of the cases that were argued and briefed for March. And we had a writ conference yesterday, and I think Judge Guidry had one also. So we had two of those, and like he said, there's a writ conferences now that we've got Zoom capabilities are going to continue to be heard on schedule. Anybody have any other?
If the one of the things that I wanted to mention is just the speed with which all involved seem to have transitioned to operating in a remote setting, and for the First Circuit to have as quickly, and Supreme Court as well, to have so quickly have transitioned to handling a docket based upon an electronic platform as opposed to what the court has done for years is absolutely amazing to me. I am, I am not a young lawyer and come from the context of, our courts slow down during the summer, and it was not for the desire not to have, justice meted out. We were doing what was necessary because the buildings didn't have adequate or any air conditioning. So I think it speaks volumes to where this country has come, that the court and appellate court is able to quickly transition to having virtual oral arguments. With that said, could the court maybe address sort of the process that you've had to go through and the hurdles that you've had to sort of address in getting us as folks that come before you to the point that you're ready to do what you're going to do on Zoom?
Again, Judge Welsh has done an excellent job as chairman of our IT committee, making sure that we purchase the licenses that we've needed for Zoom, and also directed our IT people to make sure that while we are in this process of waiting for the Zoom arguments, that the judges and the staff are being trained on what is necessary to conduct those arguments, so that we will be out of the way at the point at which you all get your notices and you start calling in to engage our IT people in terms of how to smoothly have a oral argument through Zoom, and again, to test your equipment and also give you some best practices in terms of the use of the Zoom. So that's sort of where we are in the process now. And like I said, we've been having our administrative conferences, our writ conferences, our collaboration with our law clerks by Zoom. And so we are, again, getting more and more proficient with the Zoom process.
I have to say something. This is the first time I've ever been in the presence of Judge Holdridge and not heard him.
I have a lot to say. I'm just waiting my turn. We're in the First Circuit. You have to wait your turn. It's seniority. So I have to wait my turn. I'm used to this.
One of the other things is, if there, just a personal question, and if within the cycle of things, there are at least a couple of matters that I personally had that were sort of this gray area between writ and appeal, and so I think I did the smart thing and filed both, and have received notices that writ referred to the to the appeal panel, and just wondering on timing. Those are things that sort of occurred that likely were proceeding to a June, likely proceeding to your last docket before the summer when you sort of catch up. So I would imagine they would have been on the August docket. Is there, would this sort of backlog in any way impact cases like that, or will that June catch up sort of catch that situation?
No, everything again is first in, first out, and certainly you're correct. If you have a problem with deciding, you should file both, and of course the court will act, and as you said, in your case, it was the writ was referred to the merits panel. So that particular appeal will come out in its regular order. And of course, the writ will be addressed as a part of the decision, or there will be a separate action issued on that writ. But it will be time-wise, it will both of them will be decided when the opinion is handed down.
I might add that something that we see a fair amount, and our central staff tends to pick up on it, and that is, if you have a writ that needs expedited treatment, you need to put that somewhere in the front page of the writ so we'll know. Otherwise, sometimes our people read the writ and they say, this thing's got a trial coming up in about a month and a half, and we need to expeditiously handle this thing. But if you would certainly put down that it's an emergency or it's expedited or whatever it might be, then you'll get better treatment. Now, if it's something that ought to be appealed anyway, then it's going to go to, or arguably go to the appeal panel. So I don't know if that helps any. There's one other thing that I thought about, and that is time delays, and there might be some question about that, and I don't know what everybody else thinks, because we haven't discussed this, but my thought is that if you just communicate with us, and I think that's the important thing. So once the deadlines start running again, if you can't comply with the deadlines for some reason, you can't get a transcript from the lower court because they haven't been doing anything, and now your deadlines are starting to run. If you'll just file something or communicate with us that you need an extension on your briefs or whatever it might be, then I can't imagine that we wouldn't give those. And if you give us some idea about what time you need. Normally, our debt, we give no more than about 30 days, but under these situations and circumstances, some additional time might be warranted.
As a practice point, I'd like to point out too, if you have that question as to whether you should be filing a writ or make sure that you file it within 30 days, which would be the time period for filing a writ. Because if it turns out to be something that needed to be filed as a writ and you filed it just as an appeal and you filed it on day 32, then we're not going to be in a position to convert it to a writ because it would not have been filed within the time period for filing a writ action.
That was, I think, and one of the questions that I later added questions that I received, I think we received this morning, was with regard to time delays, Judge McDonald. And I think it was, sort of in the vein of, the notions of everything being done on, May 3 or May 1. What is it good if you're not going to be able to make that date to go ahead and put in your request for an extension as early as possible, knowing you're not going to make it, or what would be the suggestion of the court?
Well, certainly you can file a motion for extension at any time. And so again, if it is pretty clear to you you're not going to make it, then you can file it prior to the reopening of the court building. So certainly, and even after the court building has reopened and those things are required to be filed, if you are not prepared to file them, then file your motion for extension and state the basis for it. And I'm sure the court will give proper consideration to those reasons.
And let me just say something about that too. We're all mindful of everything that's going on and the difficulties you're having, but we still have to follow the protocol. But we're here to work with you. We're not here to ding you or knock you out of the park. But we still gotta follow the protocols, give the reasons for the extensions, for the continuances, whatever that might be. And again, we're all in this together and we all understand.
I've been checking the chat feature and I don't see anything that has come in since we've been on. I think the greatest concern was how is the court going to, if and how is the court planning to move forward as we, sort of end the stay-at-home order. I realize you don't have a gubernatorial crystal ball, but is it? Do you think we will be extended past this end of April, or are you guys gearing up to get started at any other point?
Maybe I should interject right here that
I knew it.
You're only talking about the Baton Rouge courthouse. The satellite offices have been working and have people working in the satellite offices. So, the First Circuit is very broad. I know the judges in Covington are all working in their offices. I'm working in Gonzales, and I presume down the bayou, they're working too. So there is activity, a lot of activity going on in the First Circuit, other than at the courthouse in Baton Rouge. In Baton Rouge is where the central staff is. So most of the central staff, I think all of the central staff, are following the governor's orders and working. But in the satellite offices, you never have more than 2 or 3 people, maybe 4 at the most, in the office at one time. So it's really, work is still progressing in most of the satellite offices.
And as we pointed out before, for the Baton Rouge judges, our work is continuing as well, but it's just being done remotely and with regard to some essential people on a skeletal basis going into the courthouse. To your question, Dennis, of course, we are have some constraints. We are, of course, getting guidance from the federal government. We're getting orders from the governor. We're getting orders from the Louisiana Supreme Court. And then at that point, our court is making decisions. Some of those decisions are constitutionally and statutorily in the hands of our chief judge, but we are a collegial court, and our chief judge has been great about inclusiveness in the decision-making process. So we, as a court, the chief judge and or the administrative conference of the court, we're being guided by those orders that are coming from those respective areas. And we're also being guided by the science and the data that we are receiving, and also guided by the fact that before we physically reopen the courthouse, we have to ensure that the health and safety of those persons working in the courthouse and those of you who are visiting the courthouse is going to be protected. So those are the considerations we're looking at. There's an ad hoc committee of the court that's currently looking at the protocols that will be put in place. Also, we are always on webinars with internationally with judges that are being put together by the National Center for State Courts, by the chief judges of state courts of the United States, the National Judicial College. They are convening webinars talking about best practices, talking about safely opening courts. We were on one yesterday where we had courts from Korea, Germany, and Italy, and they were giving us what they are using in terms of the best practices, in terms of sanitation of the building, in terms of signage, and to ensure social distancing, the requirement of mask, temperature taking, all sorts of protocols that we'll be looking at in terms of best practices. So once the building is open, it will be safe for those who work there and for those who visit.
Thank you, Judge. I think, Jan, there are a couple of questions that have come in on the chat. Have you taken a look at any?
Yes, I have. One of the questions posed is one of our bar members had a case scheduled for decision in January 2020, and they haven't received their opinion, and they're wondering if that is because of the pandemic and if they will receive an opinion for the January 2020 docket shortly.
As in our ordinary practice cases, we have scheduled decision dates. Sometimes because of the complexity of the case, the complexity of the issues, the volumes that have to be reviewed, and as a result of that, sometimes a case is not necessarily handed down on its regularly scheduled decision day. I don't know the specifics of that particular case, but it may be that it is one of those cases that because of what is going on in terms of actually drafting the opinion and then circulating it to the backup judge, who also has to do research and give a letter saying whether they support or whether they want to dissent from the opinion. Then it has to be transmitted to a third judge. So again, depending on the volumes of the record and the complexity of the issues and the necessary collaboration with the various offices, it may be one of those cases that is being held up based on that, which may not have anything to do with the pandemic. But I can't speak to it without knowing the specifics of the particular case.
And difficult cases take longer to decide, and everybody has to realize that. I mean, we're not a processing plant. We actually are doing research and trying to come up with the best decision, and how good the briefs are helps out. So, you know, there's a whole bunch of factors that decide whether or not a case is going to be decided right on the decision day or not. You know, many times the judges are discussing issues and are trying to come up with the correct answer to the case. So many times you should think that if the case is not handed down on the decision day, that the judges are giving that case more attention, and that's probably a good thing.
I want to let Judge Holdridge address one issue I think that had come up, was this issue of requesting the CDs for lawyers to be assisted in writing their brief CDs of the record. Judge Holdridge, would you like to address that?
Sure. As And just to all the people that are listening here, this Zoom conference town hall should give everyone a great deal of assurance, because at the First Circuit, and I include myself in this group, we're a bunch of old dogs and we don't like change at all. So if we can change and come up with new procedures and come up and follow technology, following the lead of Judge Guidry and Judge Welsh and the other judges, anybody can do it, because we do not like change, and we would like to try to keep things like they always were in the past and not move forward. So I think this should give everybody a pause that it's possible that everybody can learn these new means of communicating and new means for the court to work. As far as CDs, the court itself is still open. Just because the building is closed, the court is open. You can still file motions. You can still request documents. You can request CDs. You can get things from the court. Just probably you need to do it electronically and try to make a request to the clerk. If for some reason you can't get a document and it's necessary for you to have that document in order to prepare a brief, you need to follow what Judge McDonald said and file a motion, file a timely motion, and ask that you be given an extension of time and give the reasons. I mean, like I said, the court is still functioning, and any motions or any requests that you need to still make it to the court. Just because you physically cannot come to the courthouse building doesn't mean that you cannot make a request, and we cannot electronically send you the request. So it's still open, and business is still being conducted. I think we've even waived the subscription fee for any e-filings, so that you can e-file very easy, and anything basically can be accomplished by e-file.
And if you would go to our website at www.la-fcca.org, again, www.la-fcca.org, there is a section on the web page that says e-services. There are various things within that pull down, and what you will find is that, again, you can request a CD that will give you the entire record. You can also, and as Judge Holdridge pointed out, we have waived the e-filing surcharge during this period. There's also, we've always had for a long period of time, also an e-case service, so that lawyers can go to this website and they can pay a fee to allow them to be able to view every document that's in a case, which they can also, print that from at their office. Of course, we have fees for that on a weekly basis, and we also have it on a 6-month and a year basis. Let's say you have one case with our court right now, you can pay $50, and in a week you can have access to all the documents you need in order to get your brief filed with the court. All those things are still accessible on our website. So we have e-notify, we have e-case, we have e-filing, and again, we invite you to take advantage of that. There may be an instance where there are exhibits that you would need to view. All you have to do is to call our clerk of court, Rod Nycan. His number is 225-247-2853. Again, 225-247-2853. And anything that you can't accomplish on the website in terms of getting electronic documents, or you can't electronically file something, you can contact the clerk of court and he will make arrangements to physically accept filings, and also, of course, give you an opportunity. For example, if you had to take a look at exhibits that have been filed with the court that you couldn't get electronically in the e-case.
I think, go ahead, I'm sorry.
No, I was finishing. Yeah.
Okay, thank you, Judge Guidry. Another question from the chat, Mr. Victorian.
It looks like the next question from the chat is how much explanation about when to expect a decision could the parties reasonably expect if one called the clerk, is the question that's currently pending in the chat.
Well, let me say, first of all, we are operating like we always operate. You can call the clerk's office to inquire as to things, but there's some things the clerk does not know. And there's certain things that the clerk can't reveal to you, certain things we can't reveal to you, i.e. who is the writing judge on the case. The clerk is not going to know necessarily a particular date that a case is going to be handed down, because the clerk of court will not know where it is in the process. It may be still in the writing judge's chambers, or it may be with the backup judge, or it may be with the third judge, or it may be being processed in the clerk's office. So you may not be able to get a definitive time that a particular case is going to be handed down, but that is no different from the usual process. And so again, you can call the clerk and ask things. They won't give you legal advice, but they'll answer what they can answer. But sometimes they really can't answer it because they are not privy to where the particular case is in the process. Because again, our cases, we are not a single, we don't operate as a single judge. Once the case has been circulated, it has to go to two other judges, and they ultimately have to vote on it. And so it may be at different points in the process. But what you can expect, that we will have a decision day for the non-argued cases that are scheduled on our next regularly scheduled docket. And for the cases that are on that docket, you can go to our August calendar and you can look at when the oral or the argued cases are going to be done. And also that gives you an idea when the public decision day is going to happen. Again, in the interim, you're going to have decisions that are going to be handed down, again, what we call out of turn, as they are fully processed by the court. And that's sort of where we are at this point.
I might add that one other aspect of that is that, as we mentioned earlier, we have 24 cases now, I believe, that are going to be scheduled in June for argument. And many of those cases are 5-judge panels. So potentially you could have a case that was on an earlier docket, and because of a difference of opinion between the judges on the panel, it may now be going to a 5-judge panel. And if it is, you should get notice, at least if it's going to be going on that June docket, you ought to be getting notice about that probably first week in May, or at the latest, the second week in May. I don't know that that answers that question exactly, but you know, some of those cases are going to be 5-judge panel cases that'll be heard in June, heard again in June, but that's our normal process anyway.
Dennis, they had a really, I thought they had a really good question that Allison Ruzon asked in the chat about processing pro se petitions. With 30 million people out of work, the pro se motion is going to be used early and often, as we would say. The Supreme Court has just came down with guidelines that we should liberally construe pro se motions that are filed with this court. And that is something that all of us need to be cognizant of, you as the attorneys for the litigants, as well as the courts, that we've got some people, a lot of people in this country that are having a tough time making it. So those don't forget that those are there and can be used.
And again, to the extent that a self-represented litigant can't electronically file whatever they need to file, again, you call the clerk of court. All that information is on our website, but you call the clerk of court, and or when you call the court's office, they will give you the clerk of court's number. And you can call the clerk of court and say that I'm a self-represented litigant. I don't have the ability to electronically file something with your court. And our clerk will make arrangements to physically accept your filing. And so we are still processing those self-represented litigant filings just as prior to the pandemic.
Mary, I think next question in the chat. Your mic.
The next question submitted is, why does the CLE form request our date of birth? So that's not something typically requested. I have another question. I mean, someone wants to respond to that, but.
Well, that's an Ann Gregory question. That's above our pay grade.
Okay. Okay. If I could ask, you would think another thing would be common sense, but I've seen on LinkedIn and some other places that some of these video oral arguments, some of the attorneys apparently are not realizing that they need to suit up and be prepared to be presentable and for the judges. You would think that that would not have to be said, but unfortunately, I'm afraid it seems that it may have to be said.
Well, again, I don't expect we're going to have those types of problems within our bar. Now is a good time for us all to be as cooperative and as understanding of the situations that we can be. But of course, certain protocols that are not affected by the pandemic should stay in place. And so we will leave that to the good judgment initially of the bar, and then we'll go from there. The other thing I want to point out too is that with regard to these Zoom conferences, one of the things that we would certainly request that if there are any motions that you would normally file during the hearings, that you file those in advance. For example, if you want an extension of the time for your oral argument, rather than waiting and trying to make that request during the Zoom arguments, that you file that request in advance so the judges have an opportunity to confer and to make that decision. If you have documents, for example, that you would like the judges to view during your oral arguments, then of course you would want to make that request and submit those documents in advance so the judges can make a decision. And of course, give them also to your opposing counsel so that they could, verify that these things are of the record. Of course, we are a court of record and we cannot look at anything that's not in the record, but if it's in the record, it's there. And so even if you don't submit it to us during the oral arguments, we have access to it. We have a electronic file cabinet, Laserfish, and every judge of the court can go from their laptop or iPad or from their telephone, their iPhone, and look at everything that's in the record. So there's really no need for you to need to submit to us a copy of something that's in the record during oral argument, because we have access to that remotely anyway. You certainly can refer to it in your oral argument, but if you really want the court to have a physical piece of paper pulled out of the record before them during your oral argument, you need to submit those things in advance, because we are probably not, and again, we're still making decisions, but we're probably not going to allow for the screen share function on Zoom for security purposes. So you wouldn't be allowed to, for example, utilize your Zoom screen share in order to place a document out of the record before the court during the oral argument.
We haven't crossed that bridge yet, but I think this brings up an interesting thing. Some people may think it's more effective arguing by Zoom than not. Others would have a different opinion that their oral argument won't be as effective via Zoom. And if you are of that mind, that means that you've got to hopefully up your game on your brief. That is basically what we go by. We walk into every hearing, we've read all the briefs, and we may have questions, but we've read all the briefs, and we have a mindset of potentially where we're going with that thing. So your brief is your intro, and is as good as you can get it. I think your brief is what is going to be the most important determiner of your outcome on appeal.
And as
Judges.
Judge Welsh and both teach at the, well, Judge Holdridge as well, but in law school, that's what we tell the law students, that your best work has to be done in your brief anyway. Once you get to oral argument, that time flies and you're not controlling that process. So even prior to the pandemic, you should have been doing your best work in your briefs. But the other reality of it is that going forward, we don't know how long this pandemic is going to last. But even beyond that, there is, when I listen into these webinars nationally and internationally, a lot of people are suggesting that this is going to be the new normal, that these types of Zoom oral arguments may go well past the pandemic. And at some point, I'm sure that there's going to be some requirement that as a part of your already existing duty to be competent in the law, that you be competent in these types of oral arguments by virtue of Zoom. And of course, you don't have to have oral argument. Oral arguments are requested. And if you don't feel comfortable, even after we've given you an opportunity to come in with our IT people and kind of walk through it, if you still don't feel comfortable, then of course you can always submit your matter on a brief. But one of the things I wouldn't suggest you do is to try to continue to file motions to continue your oral arguments with the hope that next month or the next 2 months, you're going to be physically in the courthouse doing an oral argument, because we can't guarantee that at this point. And so, again, I think we all have to do what we can to come proficient in this new technology, because it may be around for a while.
Actually, John Michael, that's in the code of professionalism now, that lawyers are required to up their game in terms of the technology that's available. And listen, this brings up a point that they're talking about. This virus may get worse in the spring and in the fall than it is now. We may have periods that wax and wane. So as John Michael said, we may be oscillating and switching back and forth between virtual versus actual. So I think this is, as John Michael said, is going to be a situation that is going to be with us from now on, I think. And it's something that we're going to be able to have to seamlessly shift between the virtual and the actual in order as we go forward in this pursuit of justice for all of us. So I think, you know, with me, for sure, it's hard to teach old dogs new tricks, but by doing law school virtually now, and the kids are becoming comfortable with it, and I guess we're having to get to be comfortable with it. So it's going to be something that's with us. So I guess it's like when the computers and everything came online, I guess we got to just gear up for it. So, but we understand.
And as Welsh pointed out again, and as I was talking about the responsibility for lawyers to be competent in the law, it says technology, but it's ever-changing technology. So just because we didn't have Zoom before, it doesn't mean that at a certain point, again, you're not expected to keep up with the changes. It's difficult, but we're doing everything we can to help you. We're gonna, you know, when we send out that notice, we're gonna give you some tips in terms of how to operate Zoom, and then we're gonna make ourselves available to actually test meet with you. And so we're doing everything we can, but we are constrained at this point to move the process along, and this is the only way we can do it right now.
We have about 5 more minutes. We have a couple of questions in the chat, but I wanted to alert everyone. I think if there are other questions that come in, we're going to pose those questions to the judges of the court, and hopefully we'll be able to post response to those questions in some fashion to folks if we don't get to all of the questions. I did want to thank the court for providing this service to not only the members of the bar, but the entire community, in letting everyone know that, you know, the wheels of justice are continuing to roll forward. I don't know. I have been amazed at just the way that everyone seems to be pivoting much faster than I thought we all would be able to. I certainly am in no position to call any of you old dogs, because I guess y'all are my contemporaries. Goodness, how did I get here? But it has been truly an honor to watch you guys doing what you're doing. I think there was one thing that we could get to real quickly, and it was a question with regard to not as I read it and trying to understand it. I think not perhaps wanting to put health-related reasons for various requests in motions to the court. How would you recommend, if there's some health-related reason, need for some dispensation from the court, to put that before the court without exposing health information?
Well, certainly, again, you know, in this situation, a lot of things are relaxed. And certainly if you basically, I would imagine that if you would say that I am in a vulnerable population, or that or that I have a medical condition that will not allow me to participate in an oral argument, I would like to have it continued, or that I have not been able to get to my office or get to my clients or to interact with opposing counsel, and therefore I have not been able to move the case along. I think some generalizations in this relaxed time will certainly be accepted by the court. So we're not expecting you to come in and to list the particular medical condition that you have.
Sheldon, you and Ann, I think everybody in the bar needs a beach trip as soon as possible after this is over. So I think y'all need to start planning a beach trip somewhere, because we all need some beach trip to some nice place after this is all over.
Judge, the sad thing is, I'm as a social person, which I don't know if y'all figured out that about me, but
I kind of noticed.
I will, I'm, and my wife might beat the crap out of me for this comment, but I would be willing to have the first round of drinks on me, and would be willing to go broke doing it, just to see and be exposed to people. I did not realize how critical it is for me to have interactions with folks, although I love my family and kids and my dog. With that said, I will allow us to make any final comments we want to make.
Dennis, I saw one question on the chat in terms of waiting room. We will be using the waiting room function for oral arguments. When you come in for your oral arguments, you will be placed in the waiting room, and then you will be brought in for your particular
anything else from that's for the good of the order?
If I could just ask one quick thing.
Yes, please.
The all of the judges be visible on one screen, or how's that going to work?
Yes.
Or is it?
Yes, you will have all of the judges visible in the gallery like we are now, and you will also have the attorneys, the appellant and the appellee visible in a gallery view. And there was another question that was on there I want to quickly ask. They were asking about whether we are processing summary motions like motions to dismiss, et cetera. We are doing those. We file them, or if you have to physically get them to the clerk, we are processing them as they come in. They may be a little slower in the process because we're operating with a skeletal crew in the clerk's office. And of course, we're working as always as 3-judge panels. And so some of these things that can't be signed by a single duty judge has to also be circulated electronically to the 3 judges to get their votes. But we are processing every type of motion or every type of filing that normally comes to the court. We are processing those currently.
Thank you, judges. I am seeing just a round of thank yous to the court and all of the bars for putting this on. And I did want to also thank Clerk of Court Prod for being the interface and getting us the information and getting us to this point. Our presidents, anything else, or is this it?
We appreciate the court participating in this town hall today. Thank you so much.
Thank you.
Yes, thank you to everyone. We appreciate it. I know it's very stressful for everyone, and we certainly appreciate some clarity and guidance from the court. Thank you.
And again, we want to thank you all. And again, this is just another opportunity for us to get more proficient in Zoom. So when those oral arguments come around, we'll be ready.
Thank you. Thank you, guys.
God bless all of you.
God bless.
Be safe.
You too.